Hi, I'm Brent Stafford, and this is RegWatch by RegulatorWatch.com. After years of bruising court battles and a major defeat at the U.S. Supreme Court just last year, the U.S. vaping industry has finally scored a major win against the U.S. Food and Drug Administration. A federal appeals court ruled this week that the FDA violated the Administrative Procedure Act when it adopted its comparative efficacy standard without following notice of comment rulemaking. FDA used that standard to issue more than 1 million marketing denial orders, producing what the court calls a de facto ban on non-tobacco flavored vaping products. The court vacated the marketing denial orders against the companies involved in the case and sent their applications back to FDA for further review. So what does this landmark ruling mean for the companies involved? And could it provide relief to the industry as a whole? Joining us today to break down the decision is Eric Goding, the lawyer who represented NicQuid and argued the case before the Fifth Circuit Court of Appeals. Goding is a former U.S. Department of Justice trial attorney and veteran regulatory and litigation attorney at Keller and Heckman, LLP. Eric, thanks for joining us today on RegWatch.
Thanks for having me.
First off, how big of a win is this?
This is a significant win. It wasn't just a win for the parties in the litigation. The rationale and the holding that the court put forth in that decision applies to the industry as a whole. So, and it kind of makes up for some of the losses that we've had in the past.
Who were the companies, the vaping companies that were involved in this case?
So it's actually 7 cases that the Fifth Circuit consolidated. So the 2 lead cases were NicQuid and Breeze Smoke, but we also had Vertigo Vapor, White Cloud, VaporMate, Elite Brothers, and American Vapor.
So this is what they call a consolidated case.
It's a consolidated case, and they consider them all together because they were similar.
So tell us about the case specifically. What FDA marketing denial orders were the companies challenging?
So these are the marketing denial orders, or MDOs as we call them, that most people are probably familiar with. Each of those MDOs was based on the same kind of underlying rationale. And that is that the PMTAs, so for the PMTAs for each of these 7 manufacturers, did not include what was called a comparative efficacy study. And because of that shortcoming, FDA then issued these MDOs without ever actually reviewing the applications themselves, what we would call full scientific review.
What did you argue before the Fifth Circuit?
So we had a bunch of arguments, and obviously our main one was the one that they ruled on, which was that both the Tobacco Control Act and what we call the Administrative Procedure Act, which is a statute that kind of sets forth your rights as a regulated entity, that those 2 things required FDA, before it ever applied the comparative efficacy standard in the way that it did, that checkbox approach, it had to go through notice and comment rulemaking so that industry stakeholders, like the manufacturers, had a chance to comment on that and tell FDA, hey, this is a good thing or not such a good thing. Here are the things you need to consider before that standard was ever applied to us. And so the court's ruling focused more on the APA part, not the Tobacco Control Act. But that was our main argument. But we did have other arguments that are still out there. The court didn't rule on them, but there are arguments that we will continue making. One is that it was arbitrary and capricious for FDA to apply the comparative efficacy standard to these particular applications. And so related to that argument is a broader argument that we have been making, and no court has really addressed this, on its face, but that the Tobacco Control Act requires FDA to do a full scientific review. They have to open up that application. They have to look at all the information and evidence. They have to balance it, each application, because each application is going to be different, before they make a decision. And one of the decisions they have to make is whether or not the comparative efficacy standard is actually appropriate. Should it apply? Is it relevant to that particular manufacturer and those products in that application? That is something FDA wasn't doing. They were just saying, if you don't have that study, you lose. And so our broader argument was that they should have done a full scientific review here, and they should always do a full scientific review and make that decision. There were some other arguments that we made here that would also be made in other cases, and that is FDA didn't consider all relevant evidence. Under the APA, again, that's a statute that kind of tries to protect the regulated community, that you have to consider all relevant evidence. And in many of these cases, there is evidence that minors are not using these products. That's one of the big concerns, of course, with ENDS. And it's actually FDA's own evidence. They do a survey every year. We know it's called the NYTS. Some people listening here probably took that survey when they were kids. And these surveys are indicating that the vast majority of products are not being used by minors. That's a huge, very important piece of information that needs to be balanced against all the other evidence and data. And FDA is refusing to consider that evidence, even though it's their own survey data. So that was another argument. A final argument that pops up in some of these cases and some of the other cases is that FDA is essentially saying that that the Tobacco Control Act applies across the board to zero nicotine e-liquids, even though the statute makes clear that zero nicotine e-liquids would not be regulated unless there's a specific intent to have consumers mix that zero nicotine with nicotine. And that was another issue that the court did not decide here.
Eric, what exactly is FDA's comparative efficacy standard? And, what has it required of flavored vape manufacturers regarding the authorization?
Yeah, so this is a really important point that I think the court, at least implicitly, understood. The comparative efficacy standard was adopted by FDA because of the high rates of underage use. And so FDA recognizes that under the Tobacco Control Act, there are competing interests here that FDA kind of needs to consider and promote, et cetera. One is, of course, making sure that minors do not use our products. That's obviously very, very important. But also recognizing that these products are lower risk and can help, and FDA now concedes this, can help adult addicted smokers move on from combustible cigarettes. And so in situations where there is evidence that minors are using a particular product, what FDA is saying is that we might still allow your non-tobacco flavored product because, kids supposedly like flavors like fruit, etc. We might still allow that on the market if the benefits to the adults are really high. They outweigh the risks to kids. And so what they did early on is they came up with this comparative efficacy study, and the rationale is the following. Kids don't like tobacco flavored ends. But adults do. And so the assumption was, and this is kind of played out, or it's kind of playing out, that FDA will start approving tobacco flavored products. So those will be out there and available to adults. So we got that, we checked that box up. But if you want to have your non-tobacco flavored product on the market, you have to show that it is better. Those flavors are better at helping adult addicted smokers either, reduce their smoking habits or completely quit. And if you can show that, then FDA is willing to take the risk of allowing your product to go on the market because the benefits are just so great, especially for adult addicted smokers. So that's the comparative efficacy test. You have to have a clinical trial, an epidemiological study, or something similar, that data, and that's costly, that takes time. It's a big study that shows that your flavors, adults will use your non-tobacco flavors more and more effectively at quitting smoking than your tobacco flavored ones. And if you do that, then you have a better chance of getting a marketing granted order.
So two things about that. One, this so-called benefit sounds a lot like smoking cessation, and that if that is the actual metric here, but the FDA doesn't allow e-cigarette manufacturers to communicate anything about smoking cessation. That's like, taboo, right? And the second part is that these studies that prove comparative efficacy, is that not what the court called out and said that's evidence of this being a standard as opposed to being, say, adjudication?
Yeah, and so that's what FDA or what the court was concerned about is that the comparative efficacy standard is just that. It is a standard that everyone has to meet across the board. No exceptions, no questions asked. So a standard is just another way of saying it's a rule, it's a regulation, it's the law. And that is not how Congress set up the Tobacco Control Act. The Tobacco Control Act envisions FDA reviewing each application independently, case by case, weighing all the evidence, and then deciding what wins the day. So it's not that the comparative efficacy analysis, that notion, is unlawful. And in fact, the Supreme Court in Wages held that it wasn't unlawful. But it's how it was applied across the board, rigidly, no questions asked, that turned it into something like a rule, a standard.
So describe for us what the Fifth Circuit actually ruled. Like, what's the ruling?
Right. So under the APA, this is, again, the Administrative Procedure Act, kind of your Bill of Rights, so to speak, says that any agency, so it just doesn't apply to FDA, it applies to EPA and FCC and any other federal agency, says that if you are going to adopt and apply something that looks like a rule, it walks like a rule, it quacks like a rule, you have to go through notice and comment rulemaking. And that's because you're applying this thing, this standard, just tons of people, tons of entities, businesses, individuals, etc. And Congress recognized back in 1945 when it was adopted, the APA, that the stakeholders, those people who are being regulated, should have a say in that before they are subject to it. And that's the notice and comment element. They propose a rule, they publish it in the Federal Register, you know about it, you can hire your lawyers or your trade association or your lobbyists, whatever, or you independently by yourself can submit comments and say, this is a good idea, this is not a good idea, this is unlawful, this is lawful, this is why we should do it, this is why we shouldn't. And then FDA, the agency, whoever the agency is, has to consider those comments. And then when they issue their final decision, here's what the rule is going to be, they have to address your comments and say, this is how we resolved them. And this is why we think you were wrong here or right here. But we didn't get to do that. All of a sudden, in a press release, FDA announced the comparative efficacy standard. We had no idea it was coming. We had no warning. We had no ability to comment, submit comments, and have FDA think through the issues that something like the comparative efficacy standard applied across the board would have on this industry, would have on adult smokers, would have it on minors, and everyone else. It didn't happen. And Congress said in 1945, if you're going to do something like that, you have to do notice and comment rulemaking.
Eric, the court was particularly blunt when describing how FDA developed and imposed the comparative efficacy rule. I've got a quote here from the ruling on screen. Manufacturers were not informed of the comparative efficacy rule before they submitted their PMTAs. Manufacturers were given no input into the closed-door development of the comparative efficacy rule, and manufacturers were given no opportunity to cure any deficiency in their PMTAs in light of the comparative efficacy rule. Manufacturers heard about the comparative efficacy rule only when FDA denied their PMTAs, with no ifs, ands, or buts. Eric, how important was that lack of notice and the lack of any opportunity to correct the applications to the court's decision?
Yeah, it's really important. I'll give you three examples. The first one is that the way they've been applying it, it's unlawful. And so we could have told FDA beforehand, look, the way you want to apply this, which is across the board without doing full scientific review, is unlawful under the Tobacco Control Act. If you want to apply that analysis and say, hey, look, we'd like you to compare your non-flavored versus tobacco flavored in the efficacy of those two, that's fine. But you have to then consider that information, that data, in the context of the entire application. That is not what FDA did here. They never did full scientific reviews. They never opened the applications except to determine whether that study was there or not. That's it. If it wasn't, you lost. That, for us, is unlawful. And we could have pointed that out during the notice and comment and perhaps avoided the problem we have now, which is FDA has been violating the Tobacco Control Act. The second point we could have made is that, look, if you do this approach across the board, without exception, it's going to result in the de facto ban. And that is not good for, one of the TCA's goals, Tobacco Control Act's goals, which is to make sure adult smokers have less risky products that will help them quit smoking. And, we could have pointed that out, and FDA could have thought about it, and they could have come to some type of resolution. A third point we could have made, and this would have been a bunch of points, is that the comparative efficacy standard, even though the Supreme Court has said, they can do it, just inherently has a bunch of problems with it. It doesn't make sense on many levels. For example, industry has been pointing out that you could have a non-tobacco flavored product that is not better than the tobacco flavored product at helping people quit. But you could have so many adults in this country using that non-tobacco flavored product that you still are having an overall benefit. The APPH standard, are the benefits outweighing the risks. And so under the comparative efficacy standard as developed by FDA, would ding you for not having that study. But it's not asking the real questions. What is the data showing regarding the use of this product? And are there really more benefits, even if they're not as good at tobacco as a tobacco flavor product at helping people quit? Are the benefits so large that we should approve this product? And there are many examples of why the comparative efficacy standard doesn't work given certain facts and situations. But FDA isn't asking those questions. And we could have, again, pointed that out during notice and comment, and FDA could have refined it. They could have thought about it, but that didn't happen.
It's interesting. One of the things that the court pointed out, two things to unpack here, but directly to what you were saying, I'll read this out here. The comparative efficacy standard affects the rights of broad classes of unspecified individuals, applying not only to thousands of existing applicants, but to an infinite future stream of similarly situated applicants, many of which already exercise property rights in the e-cigarette business.
Yeah, so that kind of goes to the due process concerns that the court had. And this is really the first time a court has kind of finally acknowledged what's happening here. You have hundreds and hundreds of manufacturers producing millions of products, investing, resources and time into developing those products, developing the marketing, et cetera, usually with the goal of helping adult smokers quit smoking. And those are, investments that had been made that were completely with one, really just one step by FDA, completely wiped out. And, in this country, we do have, a notion of due process in that before the government comes in and essentially takes away what you've built, et cetera, it's not that the government can't do that. It might have a good reason to do that, but it has to do it in a way that allows you to protect your interests, and you have some due process. And one way to do that is through notice and comment rulemaking. So the stakeholders have their say. And that's the point. If you're going to apply something that has the effect and force of law, we need to be able to have our say. And so, think about it. If Congress passes a law, presumably all the stakeholders had a chance to go to their representatives and their senators, lobby them, submit papers, testify in front of committees, et cetera. That's the due process. That's the input that is so important before Congress speaks. The same thing happens at agencies. If they're going to adopt something that's going to apply across the board without exception, absolutely, those stakeholders need an opportunity to have their say, submit their comments, testify in sometimes, agencies, they don't do it a lot anymore, but sometimes agencies will actually have, town hall meetings or an opportunity where you can actually speak and raise all those issues we've been talking about. And so when you do something instead, like they did here, which is apply a rule with literally no input. So there was no input before they adopted the rule. And even during the review process, the application review process, FDA never even looked at the rest of the evidence. So even if you could say, well, we were able to submit our evidence and our information and kind of state our case, they didn't even review that. All they said is, did they have the study? No, you lose. They also did not come back to us with what is called a deficiency letter and say, look, you don't have that study. We'll give you, 6 months to do the study and come back, and then we'll consider the entire application. They didn't even do that. There was literally no back and forth. Sometimes there were calls between staff and the folks, the applicant, but for the most part, there was no opportunity to have any say. There was no back and forth, no debate, nothing.
So when it came down to whether or not this, was an infringement, the court basically said that it's not even close when it comes to the decision.
Yeah, because you're essentially ending someone's business. You're telling adult smokers they will not have access to these products based on a rule that we had no input on.
Now, FDA could try to take this to the Supreme Court, could they not?
Yeah, they have a couple options here. They have 45 days, absent an extension, to ask either the panel to reconsider, or what we call an en banc rehearing, which is where all the active judges, so not the kind of the senior judges, but all the active judges on the Fifth Circuit would hear the case. And that's actually what happened in the wages case. If you recall, after the opinion was issued by the three judge panel, the entire court decided to rehear the case and overruled that panel. And that's the case that went up to the Supreme Court. So they have 45 days to ask for either a panel rehearing or an en banc hearing. But they could also, yes, they have 90 days to go straight to the Supreme Court with a petition.
So what are your thoughts on that?
This was kind of there was no dissent in this this decision, so it would be difficult for them to convince, I think, the panel to rehear reconsider. There don't seem to be any, major procedural errors or anything that would, merit something like that. FDA also has to think that, we've already lost once on an en banc, rehearing. And, so the chances of winning that might be slim as well. But, they won wages, right, at the Supreme Court. So you could see them uh, filing a petition for that. What I hope they do, though, the easier way out here is one, not redoing this and not doing a rulemaking, or fighting this, continuing to fight this in front of the Supreme Court. It's just to do their job, and that is to fully review each application and to consider evidence like the NYTS evidence that kids actually aren't using these products. This the specific products. There are only a few products that have been driving underage use, and the chances of a minor, if you get rid of those products, coming to another product, a specific product, is going to be pretty low. In that, there needs to be a rebalancing here. That if most products are not being used by kids, we need to figure out how to get these products to adults.
Well, let's just put a point on that because, e-liquid is considered to be an e-cigarette in the NicQuid case. I mean, they can't sell their e-liquid. So should an e-liquid be treated the same as a disposable that you can find at a corner store?
Yeah, and it shouldn't. And in fact, you know, the that type of evidence, the recent guidance that FDA just issued, they seem to be taking a little more nuanced view of these issues. They are now saying in that draft guidance, we recognize that some flavors don't present the same type of risk of underage use as some others. So we're not going to require you to show, a huge benefit of your flavors over tobacco flavors for something like spice. Maybe the advantage is only a little. And so the same rationale should apply to the type of product. We all know that the rate of underage use for open systems is far, far lower than disposables. And FDA has just yet to kind of embrace that. But perhaps that draft guidance is an indication that at least this administration is taking a more sophisticated, nuanced look and realizing, you know what? We need to consider that type of information. And so, perhaps the industry is, forced back to open systems. We have things like the biometric, age gating type stuff, which is great, which could work for disposables as well. But setting that aside, should FDA be pushing industry to e-liquids? Because kids, they're not using that. The rate's like 5% or something.
So at the top of this episode, you mentioned that this ruling is going to affect all other vaping companies that have received MDOs.
It could. So especially going forward. So, if FDA, if they see what they've been doing is indeed unlawful, they are going to have to take a different approach for any, new applications. And, presumably that approach is to do a full scientific review and consider all the relevant data and evidence and whether or not the comparative efficacy requirement should be applied to that particular product and that particular manufacturer. They could try to do something else. So without a doubt, going forward, this is a very important decision.
Is it fair to characterize this ruling as something that has dismantled FDA's current approach to denying mass denials of PMTAs?
Yeah, if yes, absolutely. If this decision stays, it sticks, it has undone FDA's entire approach to non-flavored ends.
So, if you're in the U.S. vaping industry, should you sleep a little better tonight?
Yes, they're going to be, there's still some question marks. We need to make sure this opinion sticks. But this was a shot over the bow by the Fifth Circuit, and a court finally called out FDA for what they're really doing. And I'm not saying FDA is not acting in good faith, but they had their reasons to do this, and it's not lawful. And so I do think if this sticks, and FDA has to deal with it, that this is a big win for the entire industry.